First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save you, the United States, the great state of Florida, and this honorable court.
Thank you, Mr. Marshall. Welcome to the First District Court of Appeal video conference oral argument. We have one case on the docket this morning. It is Ed Crapo as property appraiser versus University Cove Partners, case number 192894. Mr. Dent, you may proceed when you're ready.
Okay, may it please the court. I guess I'm supposed to tell you my breakdown. I would probably divide it equally, approximately 8 minutes, 7.5, 8 minutes, and then save the rebuttal, if that's okay with the court.
Yes, sir.
I'm John Dent, representing Ed Crapo, who is the property appraiser of Alachua County, Florida. This is obviously everybody has agreed to the facts. There's nothing in controversy. This has to do with actually a match between the acts of Congress in creating this credit system to help encourage private sector to development, low-income housing, with the state of Florida legislature in their attempts to provide an additional incentive for the private sector. This section was added to provide for profit entities to come in and start providing low-income housing, and to do that rather than on the other part of this section that we're looking at in the code deals with nonprofit and affordable housing. And of course, they're 100% exempt when they qualify the project as defined. This was designed to provide a means to take the incentive by Congress in creating tax credits for the private sector profit parties to get involved, and the legislature in Florida decided that they would also encourage by providing for this reduction in value of 50% for those entities that qualify. Now, in trying to mesh the acts of Congress with the Florida laws where we're having our dispute and trying to interpret the contract, we think it's pretty simple. And the main thrust of this is if you look at or section 26, I think, Title 26, Section 42, which is the Housing Act of that Congress created, and these tax credits. The basic assumption provided in that is that each building is a separate project. The definitions of the words that they have chosen to try and delineate the timing of the various aspects of the act deal with each building. If you read the definitions that are included in the code, federal code, you'll see that they each individually. The agreement.
Counsel, do you agree that the extended use agreement addresses the extended use period of an affordable housing provider?
Well, the extended use, that's what they bid on, is that they come in and these are awarded on a competitive basis, and so they look at the qualifications first. The length of time that the developer agrees to keep these in low-income housing is one aspect in the bid process, and also all they offer for the housing authority then to go through all the applicants and make a choice. And that's the end game, is how long these things are in. But we think the critical part of this, as I say, each one of these periods, the credit period, each of the other definitions we have, all apply to a building. And why that's crucial is because there's an option that you can vary, and you could have, when you have, as in this scenario, you can have buildings with a different timing. So which one do we use in calculating? If we rely on the definition of the Federal Act on a term that applies to the building, the credit period applies to that building.
Mr. Dent, let me ask you a question, though. I mean, isn't it true that at least as of 2002, all of the buildings were available for service? And why should that not enter into our interpretation of the term of the agreement?
Well, because none of them can achieve the benefit until there's an agreement signed with the state housing authority, so that nothing can start. You can have these credits, and some of them, they started this project earlier and they have all their time periods, but none of the restrictions apply until that agreement's signed.
Could the agreement be effectively backdated? I mean, here I understand the argument to be something like that. The agreement was signed May 2003, but it went into effect 18 months earlier. Is that impermissible?
Well, you get into an interesting topic. In some areas it is, some it's not in this. But we're looking at what did the legislature have in mind in these restrictions. And two, generally when you have something that occurs like that, it's specified. If the state legislature or with the housing authority saying that this agreement, even though it's signed this date, is effective back on one of the other dates and brings that in, we wouldn't be arguing, but they didn't do that. What the legislature had to look at when they enacted this provision was what was going on. And that is—
Counsel, could the fact that the tax discount issue applies after 15 years means that the legislature intended for the discount to apply to those entities who continue offering affordable housing after the compliance period and into the extended use period?
Well, I'm going to disagree, and they didn't do it after the compliance period. What they did is they said that they will be, if they remain in existence for 15 years after the term of the agreement. They didn't use— if I wouldn't be here arguing, if the legislature said if they did 15 years of the compliance period as defined by Title 26, Section 42 of the Internal Revenue Code. No, they didn't. They tagged it to the effectiveness of the agreement that was signed. They specifically tied it to that. When they defined the term commenced when the document was executed. And that's the only time under Florida law when the restrictions applied, when that agreement got signed. So
I want to ask about the tax credit forms. It's my understanding FHFC signed University Cove's tax forms for a period that included 2002. And if that's the case, doesn't that, I guess, supplement the argument that the governing period or the term of the agreement really includes beginning 2002 once the restrictions were in place?
Well, I don't see that the agreement, if you're referring to the 8609 that's signed by the housing authority, it doesn't have that language. It just has that they signed it as of May 21st, 2003. That's until then, under Florida law, these units were not restricted. Again, what we are trying to do, and you can have hypothetically of these now, is specifically under this development, they made the election that each building is a separate project. They did not elect that this is a multi-building. So when you look at the Internal Revenue Code, in fact, one of these is 2001. Hypothetically, you could have 15 years when that was placed in service, which would be different from the 15 years of the other ones at the election under the code. And that's the difference. You could have hypothetically a project under the agreement that's 130 units. Now, if you had half of them that were in 1 year, half in another year, then you divide that in half at 65 and none of them would comply. But you're tying the Florida Act to the Internal Revenue Code.
Counsel, how do you reconcile your interpretation of the term of the agreement with the fact that the restrictions set forth in the agreement must be followed during the extended use period?
I agree. They have to be followed during that period, but they don't commence until the agreement's signed. So that's the start date for the 15 years. Until under the Internal Revenue Code, until that agreement is signed, according to the Florida law, until that agreement is signed, there are no restrictions on the property. So
but if the agreement had been executed at the same time that the affordable housing buildings were put into use, would you agree that the term of the agreement would have been the extended use period?
No, I wouldn't. And the term extended use commitment is a qualification under the Internal Revenue Code, which defines that the length of time into the future that these units exist, and they've committed under their proposal to Congress, or to the Secretary of the Treasury and to the State Housing Authority, that they've agreed they will maintain these units for a certain length of time. What we're looking at here is meshing. We got Florida law. Now, Florida law says, according to the statute, when the term of the agreement commences, you got 15 years and we'll give you a break. It's strictly related. If you can assume intelligent life over in the legislative branch of government, they could read these. They chose not to say if it's 15 years under the compliance period, they could easily have done that. They didn't. They tagged it to the term of the agreement, which is a defined paragraph in the agreement itself. We have to assume that the legislature can read. They saw this agreement, they saw what the term was, and it commenced on the effective day. That's what they wanted to assure. 15 years under the agreement. That's what it says, under the agreement, 15 years. After that, you get the break. Not what tagged it to what
importance do we put on the term recorded agreement? This says that the agreement actually has to be recorded in a couple of places here. Is that also a qualifier here that matters?
The recording of it?
Yes.
I'm not sure I understood. The only thing it's tagged to is the effective date of the agreement, which is what the legislature referred to commence the term of the restrictions under the agreement. Until that agreement's signed, there are no restrictions on the property. That's what the legislature was looking at. The legislature could have easily read the Internal Revenue Code, said, okay, on the date they're placed in service, that's all they had to do. Or the commencement of the compliance period under the Internal Revenue Code. They didn't. They chose to use the effective state law term of the agreement when it commenced. And there's nothing to indicate that they wanted to refer to any of these other terms. And really crucially in this is that under the code, those terms don't have anything to do with the project that's defined in the agreement. They all apply to each individual building. So you're taking a leap going from the extended use period of a building and et cetera separately and trying to apply that to an agreement that logs them all together as a project under Florida law. Remember, this is not a project under the federal code. These 14 buildings are not a project as defined in the code. 14 separate buildings are each a separate project.
Mr. Dent, you're welcome to continue. I just want to let you know you're down to about 3 minutes.
Well, I can stop here unless anybody has a question. I certainly would defer if you all have a question.
Well, we can certainly save the remainder of your time for rebuttal.
Thank you.
Ms. Dixon, are you still a part of the conference?
It looks like she just dropped off. I'm going to try to get her reconnected now, judges.
Okay, thank you.
Can I argue? Never mind.
We'll take a break.
We'll take a break. Okay. This is interesting.
Mm-hmm.
I've been doing this 53 years, and now this is the unique situation.
Ms. Dixon, is that you via phone?
I'm here by telephone. I'm still trying to log back in.
Okay, we can hold just a second and see if we can get you reconnected via the internet. If that doesn't work, we can proceed by telephone.
Okay, let me try one more time to log in. seem to have an internet issue all of a sudden.
Maybe that's the chief.
Chief, given
sir.
the technical issues we're experiencing with Ms. Dixon, are you okay if we proceed with her via audio only on the telephone?
That's fine with me, Ms. Dixon. Are you able to proceed by telephone at this point?
Yes, that's fine.
Okay. Well, you may proceed when you're ready.
Thank you. May it please the court. Jennifer Dixon on behalf of University Cove Partners. I missed the tail end of Mr. Dent's argument, but I don't think that there is any dispute that the statutory language of Section 196, 1978 is clear. It's unambiguous. The discount should be applied on January 1st after the 15th completed year of the term of the recorded agreement. The only issue is, what is the actual term? Or more accurately, when did it start? The first question is, can the commencement date be established solely by a declaration of when the contract is effective? And if not, did the trial court properly consider the totality of the agreement, specifically the extended use period, which was triggered by the credit period, in determining the actual term of the agreement? In our opinion, the answer to the first question is decidedly no. Unless it's expressly stated in a contract, the effective date or the signature date alone does not establish the term of a contract. The property appraiser cites no authority for that proposition, incidentally. Nothing in Section 196, 1978 supports that conclusion. The agreement itself doesn't support that conclusion. The suggestion that the arbitrary date...
Ms. Dixon, this is Judge Osterhaus. Why isn't the agreement patently clear? Section 6, it's entitled Term of this Agreement. This agreement shall become effective upon the date the corporation executes this agreement, which I understand to be May 2003. What I understand you to be arguing is not that this agreement shall become effective upon May 2003, but that this agreement already was effective 18 months earlier. It seems to be patently to contradict the term of this agreement.
Well, I think there are a couple of reasons for that, Your Honor. First of all, the tax discount issue did not exist at the time this contract was drafted, so perhaps the drafters were not as particular as they could have been. But it is not uncommon in contracts for an effective date and a commencement date to be different. We see it in leases all the time. You know, I may move into an apartment and the landlord doesn't get around to signing the lease until a month later, but my tenancy still began when I moved in. So I don't think that you can automatically conclude, as the property appraiser suggests, that an effective date, the go-live date for a contract, is effectively the same thing as the term. It doesn't establish commencement.
Ms. Dixon, this is Judge Ray. Let me just follow up on Judge Osterhaus's question and ask you to respond to an argument that the appellant made that under Florida law, buildings were not restricted until the agreement was signed in 2003. I assume you disagree with that, but you can explain why.
I absolutely disagree with that, Your Honor. The University Cove was bound to very specific obligations that burdened the owner from the commencement of the extended use period. Section 2 of the agreement really sets forth the majority of those. It required University Cove to operate as a low-income housing project, beginning when those buildings went into service. It required that they be leased to members of the general public. It required the University Cove to provide a computer lab for residents. It barred any conversion to condominiums. It barred any owner occupation of units. All of these obligations commenced at the beginning of the extended use period in January, not when Florida Housing signed the agreement.
Under what agreement? Is there anything written that says that?
Well, the agreement itself in Section 2 establishes those obligations, and it it runs from the beginning of the extended use period. And it's telling that in Section 6, the agreement runs through the termination of the extended use period. So that period is very significant in determining the term of the agreement.
Ms. Dixon, we have you back again.
Okay, I don't know if you want me to switch to computer audio or if we're fine on the phone. I don't want to conflict and cause feedback.
Please pause the clock momentarily. Mr. Corzine, what do you recommend? Should she disconnect her phone?
Let's leave the phone audio. That way, if we do lose her via video again, it won't disrupt the argument, but we'll also still be able to see her.
Okay.
Perfect.
Thank you. Ms. Dixon, I actually was going to ask you a question. As a practical matter, if University Cove had failed to comply with one of the restrictions in that first year before the effective date, for example, it started using the units on a transient basis, what would have happened to the agreement?
It would have lost its eligibility under the Florida Housing Agreement. But if you take Mr. Dent's construction, if that had happened and the contract wasn't effective, then Florida Housing would not have any enforcement ability for anything that occurred prior to the effective date. And I don't think that that's giving credence to the entire document. I'd like to just remind the court of a case that is cited in our answer brief, which is Maines versus Davis. It's a 1995 case, I think. And this court was asked to determine whether an employment agreement failed to specify the term of employment, whether that was void for uncertainty. In upholding the agreement, this court applied 6 basic rules of contract construction, 2 of which are really relevant here. First, that a contract should be construed consistent with reason and the practical aspects of the transaction. And second, a contract should be considered as a whole and not in its isolated parts. In Maines versus Davis, this court reversed the trial court and determined that notwithstanding the fact that the agreement wasn't signed until January 30th, 1994, the term of the agreement actually began on January 1st, 1994.
So could this agreement been executed in 2015 and backdated to 2002 just the same? I mean, does it matter when the recorded agreement under the statute requires a recorded agreement and talks about 15 years afterward? But could the agreement just be a year old and still be backdated 15 years?
I think for the purposes of this tax discount in that universe, I think that that's true. I think it doesn't really matter when the contract was recorded or signed, as long as it is recorded and signed. The key term in the statute for the discount is what is the term. And although Section 6 states that there is a term of the agreement, it talks about when it's effective and when it terminates, but it is silent on commencement, much like the contract in Maines versus Davis.
This is Judge Lewis. As a follow-up to Judge Osthouse's question, how could the term of the agreement include a period of time that occurred before the agreement was executed?
As I stated, it happens all the time, Your Honor. It happens in leases. It happens in other agreements where the party's obligations may not be established at the same time as the contract is signed. And I will say that I don't think the legislature intended that a developer's entitlement to a tax discount be triggered by a signatory at the Florida Housing Corporation. I think that the spirit of the statute is the building should be in service for 15 years. It shouldn't be established by the arbitrary date of a signature when we all know that documents can sit in agency inboxes for weeks before they actually get signed.
Are these agreements with the Florida Housing Finance Corporation usually executed in the same year that affordable housing buildings are put into place?
I wish I had that answer for you, Your Honor. I simply don't know from a sort of common use how that really happens in Florida housing.
But effectively, you're saying that this agreement began January 1st, 2020, when there was only one of the 14 buildings in place. So there's only one building being used at the time for this purpose, and yet
Your Honor, that actually is the last date.
was in place.
January 1st, 2002 is the date that all 14 buildings were in service. They actually started going into service in 2001. So January 1, 2002 is the outside date.
Okay, I thought that your brief said only one building came into service in 2001 and the rest of them during the first half of 2002 sometime.
Correct, but the last, it also goes retroactive to January 1st of the date that the last building is placed in service. And just to reiterate, there was no dispute below that the credit period, which is a defined term in the contract, was established as of January 1, 2002. And by that time, that was the tax year that all 14 buildings were placed into service. The credit period goes back to January 1st of 2002. And the credit period is what triggers the compliance period, which is what triggers the the extended use period. So really, there was no factual dispute about January 1st being that trigger date.
Ms.
My video is frozen.
Since the term is not defined in the statute, nor is it arguably defined in the agreement, and if there is more than one reasonable interpretation of what term means, why should we not strictly construe this agreement against the taxpayer as we are required to do for ad valorem tax cases?
Well, I find that an interesting argument that Mr. Dent was making, and certainly tax exemptions, it's a common maxim that tax exemptions must be strictly construed against the party claiming them. That's not what Mr. Dent and Mr. Crapo are doing here. What they're trying to strictly construe is the agreement. The agreement should not be strictly construed. The agreement should be given its full effect, and all of its provisions should be given their full effect. This is not a case where we're trying to figure out what the legislature meant when it we're trying to figure out what the contract means, which is not subject to strict construction. Instead, we're looking at contractual construction, which requires that all of the provisions be given effect. And if you take the position that the effective date is the commencement date, then all of the obligations that predate May of 2003 are not enforceable. So I don't think that is what the Florida Housing Corporation, certainly don't think that's what the parties intended when they entered into the agreement. And before I have about 3 minutes, I want to just make this larger policy issue, this policy argument, because I don't think that policy here should be ignored. The property appraiser, in advancing this strict construction argument, kind of fails to recognize that this tax exemption is afforded to developers as an incentive. It's supposed to incentivize private developers to invest in low-income housing in the state. That policy is actually codified at section 420.003, and it provides that, quote, state and local governments shall provide incentives to encourage the private sector to be the primary delivery vehicle for the development of affordable housing. The state's lack of affordable housing is still a key issue for the legislature. Just last month, they allocated $370 million for housing projects in the state. And an unduly strict application of the affordable housing tax discount by local property appraisers undermines exactly what the legislature is trying to accomplish here. Advancing an overly...
Go back to the agreement, the language of the agreement itself, to make sure I understand, because I find it a bit nuanced, and I just want to make sure that I grasp it. So this agreement was in place as of, your argument is this agreement was in place as of January 2002, and we have a term of this agreement that says this agreement shall become effective upon the date in which it's executed. So the agreement wasn't effective until 2003, but it was in place in 2002. Do I get it?
It was effective. It effectively went live in 2003 when the corporation signed it. However, the agreement itself imposed obligations retroactively. And if University Cove had not complied with those provisions, then they would have been in breach. So if you say, so the commencement date is established by when those provisions went into effect, not when the agreement itself was signed. If you take the position that it was when it was signed, that the obligations commenced then that kind of obliterates all of the 2002 obligations that University Cove was required to comply with.
Counsel, is the agreement at issue in this case a form agreement that was in existence when the legislature created the tax discount at issue here?
I don't know the answers to that, Your Honor. I wasn't even a lawyer yet when this agreement was signed, so I don't know the answer to that. If there are no further questions, Your Honors, I will rest. Thank you.
Thank you, Ms. Dixon. Mr. Dent, you have about 2 minutes and 40 seconds for your rebuttal.
Right, two quick things. First of all, we're not here because we've denied the 50%. But it's only 1 year. So we haven't denied the project. What we've said is the timing. In answer to that, I've done a lot of contract law in the 50 years of practice. If you're going to make a contract effective, you have to say so in the contract, that the effectiveness of this and the binding aspect started at a date prior. This legislation does not do that. It doesn't say 15 years from the compliance, etc. Also, the Secretary of the Treasury controls these restrictions. The federal code says if you don't sign this agreement, the credits are not any good. So everything's contingent on the date this agreement signed. The restriction.
While the agreement was not executed until May of 2003, then the Florida Housing Finance Corporation then signed Apple's federal tax credit forms for the periods of time in 2002.
No, they signed them effective date when they signed it in 3. They didn't sign off. There's nothing in that application that defines what we're talking about. All it does is say when they're placed in service. Under the Title 26 of the code, those restrictions are not effective per the code until this contract is signed. That's what the IRC says. So everything is contingent upon anything being binding on anybody till this contract is signed, either under the federal code or here. But I remind you, all of these restrictions and these time periods they're talking about apply to a building, not to the project. And I don't think the legislature technically has the authority. Now I can't to adopt and reply and have everything their contingency based upon what the Secretary of the Treasury does in accepting. Remember, there's optional dates on each one of these buildings on when the credit is allocable. They can collect different dates on them. Once you do that, now you're saying, well, we have to look and ask the Secretary, well, what date are we effective on these? And that the exemption is binding tied to that. I just don't see we're going outside the realm on this. Also, these agreements were in effect at the time the legislature did. This program under Section 42 has been around. The legislature came along later and adopted this 50% break. And I think if you look at the timing of the title adoption, the title Section 42, Title 26 on granting of these and allocating them. They were originally designed not for the Florida tax exemption. They were designed for the establishment of this credit program to encourage private sector. The legislature in Florida came along later and provided the additional incentive.
Well, thank you, Mr. Dent. Your time has now concluded. I want to thank you. I want to thank Ms. Dixon for your very helpful arguments today. The court now stands adjourned.